Moving forward, friends, to understand pledge, we will quickly run through this. This is more in terms of loan or money that is granted. But I think when you try and understand about pledge, you try and make distinctions between the different kinds of money lending business that is there in India. The informal sector we usually call pledge as similar to what we call as pawnbroking. Now, pawnbrokers are there in most cities. They are local money lenders. What they do is, if you go and give them some kind of a valuable good, usually it is jewelry, it is gold, it is silver, which they actually take it. And if you want immediate liquid cash, I think they are the ones who can actually give it to you. So pledge is a more formal sector. Maybe it involves banks and financial institutions where they give you money or loan advance. And now what is interesting is banks always need security before they can give you the loan, because there is always this risk that you will default. So they ask you to give something as a deposit, as a valuable. And please note, pledge is only of goods, whereas mortgage is usually used for immobile property. So it's the same thing, right? If you keep your house or land as security, then you enter into mortgage. But if it's anything that is mobile property, especially what we call as goods, because there is a distinction between mobile property and goods, then you have entered into a contract of pledge. Now, one of the most interesting aspects today that you would want to just deal with is what can be pledged, right? Does government also enter into pledge contracts? Yes, they may. In certain circumstances. For example, the modern form of pledging property that is involved is shares. Shares and stocks can also be the subject matter of pledge. So banks like this because it's valuable in terms of market conditions. It does not require too much of storage space, and most importantly, there is no threat that it will be stolen. Now, if you keep gold, there is always this threat that someone will steal it, and so on and so forth. So shares and stocks are an easy security that most of these banks generally accept. What is also important and relevant today is when we talk about property, the tangibility of the property was very important during early times. But today we are talking of immobile property under the contract of pledge as well. So intellectual property can also be pledged. So we have trademarks that are pledged, patent rights that are pledged, and they can also give you some kind of money or money's valuation, as the case may be. The third part is hypothetication, friends. This is something that you will see that the SURFACE Act, that is called the Securitization Act, deals with in some matter. And hypothetication is kind of a modern kind of pledge. Interestingly, some authors have called hypothetication as a pledge in abeyance. You know why? Because in hypothetication, you can use the goods. It's not going to be kept as a dead security with the bank. Pledge, that is the disadvantage, that the bank just keeps it but cannot use it. You cannot generate money out of it, you cannot generate income out of it, and then it becomes difficult for the borrower to actually repay the loan. Now, if I keep this goods as security, but I can actually monetize the goods, then it's easy for me to repay the loan back. So hypothetication is generally and a common practice with taxis or with automobiles which are taken on loan or rent, where the driver or the owner gets to use the automobile, but it's still kept as security with the bank, right? So that's what hypothetication in the actual sense and meaning looks like.
If you are taking to understand two important points in the contract of pledge, first is who can pledge and what can be the subject matter of pledge. Now, to understand the subject matter of pledge, friends, it's important for us to understand that the Indian Contract Act says that pledge is a type of a bailment. Yes, it is bailment because in pledge, first, the borrower would want to keep something as security with the bank, where he delivers these goods for a particular purpose. And what is the purpose? The purpose is for a return of cash or a loan that he intends to take. So in pledge, the bank just keeps these goods as security and does nothing regarding the same. And that's why the Indian Contract Act also says they have a general lien over those goods. However, you should also understand that under Section 172, where there is a definition of pledge, and the chapter on pledge, when one looks at it, you will come across the fact that apart from goods, the title to the goods can also be pledged. Because see, interestingly, in India, even now, as we look at a lot of digital transactions, a lot of goods don't have title deeds. There are some goods that have title deeds that is given by the government or there is a recognition of the same. But many goods just are based on the receipt of the purchase on which the title to the goods are claimed. And that's why traditionally a railway receipt um, is also considered a title to the goods. So if goods are given to the railways and then you get a or you can generate a receipt for the same, that is a title deed to the goods. And this is something that is defined under the Sale of Goods Act. What can be considered as document of title to goods? And hence you will notice that these kinds of document of title to goods can also be pledged, right? So it's important for us to understand that the subject matter of pledge is quite vast. As I told you in the past, an intellectual property can also be included in the subject matter of pledge. Also interesting that you have to note down is that shares, when they are pledged, there has been change to the Depositors Act about how some of these shares can be pledged. And one of the most common forms of pledge is the promoters who pledge their shares to raise money or loan for the company. Shares are quite a favorite subject matter of pledge for the convenience of the same, including the current way in which shares are kept in a dematerialistic form. Also, once you have understood who can pledge, you should also understand that usually it's the owner of goods that can actually make a pledge. However, when you read the Indian Contract Act, there are some very interesting additions to the rights of the owner. And apart from the owner, an agent or a mercantile agent in the ordinary course of his business can also pledge goods. And this creates that interesting aspect of the fact that agents can also pledge, and that pledge is valid. The only condition is that it should be done in the ordinary course of business and for the purpose of the business. So pledges are, kind of, quite a broad aspect. It adds to the discussion of what we have already seen under contract of bailment. Now, when you look at the mercantile agent, friends, the conditions are some of these. That he should be in possession of the goods, the document of title to the goods, with the consent of the principal. It should be something that is required in the ordinary course of his agency business, and it should be done in good faith. If these three conditions are fulfilled, a mercantile agent can go ahead and pledge. Now, agent and mercantile agent, one understands that a mercantile agent is one who has the right to trade on behalf of his principal. So the best example for a mercantile agent would be a car dealership showroom. That's kind of a mercantile agent because his duty is to do commerce. His duty is to sell for his principal. He is kind of an agent who actually trades for his principal. And those kind of agents can also go ahead and make pledge. Why do mercantile agents get this right under Section 178? Is for the simple reason is that in early times, you actually would appoint an agent in a place where you are unable to be present. And probably there is lack of communication during those days. Right now, I don't think that can be an excuse. And you had to probably look or take care of the goods. You may need some cash to deal with the goods, and hence you should have got this right to actually pledge the goods because it's a temporary kind of delivery or giving the goods for some kind of a money advance. Those were the kind of justifications where agents also have the right to pledge. Interestingly, Section 179 also says that a person with limited interest can also pledge. Now, the term limited interest here clearly means that you do not only have the possession of the goods, but you have a proprietary right on the goods as well. That's an additional kind of a right that you have. And hence, under Section 179, what probably one will have to include is the aspect of sub-pledge, which means a bank goes ahead and sub-pledges it, right? So if the bank says, look, I have created an interest in pledge. Now, pledge creates that interest. How does it create the interest? Because you have got the money there. So to the extent of the money that is lent, the bank will have an interest in the goods. Now, to the extent that the bank has an interest, they can go ahead and sub-pledge under Section 179, right? Like, in contract of bailment, we said Sub-bailment is also possible in certain cases where customary practices or with the consent of the bailer it is required for the purpose of bailment. Sub-bailment is possible. Sub-pledge is also something that is possible under section 179. Also, when you look at pledge by non-owners, one of the cases that one would like to see is the Philippe versus Brooks case. This case is a case under section 178A of the Indian Contract Act, which, please note, friends, is an addition. It was not part of the original law. It was later on added because this said that, look, certain kinds of pledge are valid if they are done under a voidable contract. Now, in Philips versus Brooks, this is a technical case, and I think one will have to understand in what context pledge becomes valid in this case. But it is important for us to understand that voidable contracts are to be held voidable, either by the court or at the option of the parties who feels that their consent in the contract has been vitiated by fraud, misrepresentation, undue influence, or coercion. If you decide to exercise that option, it becomes voidable. If you don't decide to exercise that option, then the contract is valid. So when the contract is valid, though it is supposed to be voidable, any kind of pledge is considered to be valid. Right? So in these cases, time becomes a very critical element to decide whether the pledge is valid or invalid. Right? So the case of Philips versus Brooks is something that we can look up to. It's a very technical and an interesting case which brings in the very element of time for rightful ownership of a contract. It talks about time with which third parties can either get rights or not get rights. It also talks about the issues or challenges of pledge because most of these lack document of title to the goods. Right? So that is what this case actually magnifies. Now, moving forward, friends, is the pledgee or the pawnee, as the case may be, which is the bank, a secured creditor? Now, please note the relationship between creditor and debtor is divided like this. Debtor is the one who borrows, creditor is the one who lends. Now, because the one who has lent, that is the bank or the pawnee, as the case may be, they have certain goods as security and they are a financial institution, do they be considered as secured creditors? Now, the aspect of secured creditorship, friends, as a concept, you must understand is because of the fact that you get the first rights to get your loan back. You have the first right to recover. That's what a secured creditor is, as against unsecured creditors. Now, you will notice that once goods are pledged, and if the bank has the physical possession of the goods, the one who has physical possession of goods always will get the first right over the goods, and he becomes a secured creditor. Not secured in terms of the goods that are kept, but secured vis-a-vis the recovery of the loan and the purpose of the loan. So in this Bank of Chittoor versus Narsimhabu Naidu, it was held that, look, if there are few one good and it has more than more than one claimant or two or more claimants. So security is one, but there are two or more claimants. Then who should get the first right over the goods? Who should get the possession of the goods in the first instance? And the court said that in a pledge, it creates a secured creditorship, and the banks will have the first right on the goods unless their loan is discharged, unless their rights in the contract is discharged. No other person can get rights on those goods. Right? So that is how a secured creditorship comes into place, especially when liquidation happens or when bankruptcy happens or when someone is insolvent with whatever is assets. If you have to pay the creditors, then the rule of secure creditorship becomes a very critical role and they get the first right over those kinds of assets. So I think understanding these aspects in contract becomes quite relevant for commercial day-to-day understanding, especially if you are dealing with government contracts. I think these are concept becomes very relevant and important. What is also important is to look at the rights of a pawnee. The first right of a pawnee is to the right of retain. Interestingly, this is like a right of lien, though right of retain is considered to be a largely broader than right of lien. And the drafters have very clearly said, look, the pawnee has the right to hold the goods till his debts are paid off. But interestingly, it's not only towards the debt that the bankers or the banks can retain the goods. It is also for the interest on the debt. So principal with interest and any kind of ordinary or extraordinary expenses that the bank have incurred in the pledge, they can actually hold on to the goods. They need not return the goods back unless those are actually paid off. Right? That is where the right to retain is a broader right. It's a right of a creditor. It's the right of the pawnee. And this is a legal right. He need not hand over the goods. It's an exercise of right without the intervention of the court as well. So the pawnee also has the right to recover extraordinary expenses. Of course, this is something that he always has this because, if he takes care of the goods, and naturally when you take care of the goods, you may incur certain expenses of storage, of preservation, or etc. Those rights also the pawnee can exercise and he can recover it from the pawner. So under the contract of pledge, friends, you will notice that the rights of the pawnee, that is one who has lent the money, has been secured, has been mentioned, and that was the purpose of the Indian Contract Act's drafter in saying in pledge, now we have to take care of the rights of the pawnee. If we take care of the rights of the pawnee, they will lend. That is how business, commerce, and trade can happen, and that's the purpose of calling this a special contract and defining the rights and obligations of the parties in the contract of pledge. What are the remedies available to the pawnee? Of course, he has the discretion of bringing in a suit. Now, please note why, because you already have goods, so you don't have to actually bring in a suit. That's his entire discretion. At the same time, he can retain the goods. And please note, this discretion is something that is completely left to the pawnee. No one can force him to say that, look, you first sell the security and then bring the suit. No. If you read the provisions of the contract law, the pawnee has an entire discretion, and the pawner or the borrower cannot say you do this or you do that. Right? You first sell the goods, you sell the securities. From that sale, if you are still having any kind of claim, only then you can file a suit. This is usually a kind of a misunderstanding that a lot of people have, but the contract of pledge very clearly states otherwise, and it gives the entire discretion to the pawnee. They can choose to recover the debt in whichever manner they want, either file a suit or they can actually retain the goods as well. Now, the Vimal Chandra Grover case is a very, very interesting and a very fine case on the right to sell. So you should probably read this case because it's a case on a very important point. And the point is, see, the pawnee can sell the pawn property. Okay, he can sell it. That's not a problem. But when does he decide to exercise the right of sale is entirely left to the pawnee, right? Now, in case he has not committed any fault on his part, what can those faults be? Now, for example, in Vimal Chandra Grover case, the question was, whatever the secured property which is there. Now, when do you exercise the right of sale? When there is a default, right? The debtor has not paid the debt, or when the debtor fails to pay the debt, or when he delays in paying or repaying the same debt. That is only when a pawnee would right to sell the secured property, correct? Now, at this point of time, when there is a default and the bank wants to exercise the right of sale, suppose the bank has misplaced the shares or they have lost the shares, they have actually taken a lot of time in locating the shares. In those circumstances, that could be an aspect of negligence in taking care of the goods as if the goods were your own, because that is the whole principle of bailment that will apply in this case. Now, please note, in bailment, once the purpose is accomplished, you have to return the goods back. So the bank has a duty to return the goods back even in pledge once the purpose is accomplished. Now, if there is negligence on the bank, I think the borrower has every right, the debtor has every right to sue the bank for that kind of a negligence. However, he cannot insist that because of the delay, his rights got affected because the share prices fell in those 9 months, and that's why he would want the pawnee to be held accountable. That he cannot possibly sue the pawnee for, because that's a choice, that's a discretion about when he wants to sell, whether he wants to sell or not in the first place, or whether he wants to bring in a suit. Now, interestingly, to bring in a suit, please note there is a limitation time. Under the Limitation Act of 1963, the ordinary limitation time to file a suit for the recovery of the debt is 3 years from the time of default, or from the 3 years from the time the cause of action has arisen. And if the 3 years gets expired, the creditor cannot bring in a suit against the debtor, right? Because the limitation time has expired. So no suit is entertained unless probably there is what we call as condonation of delay. So that is one kind of a plea and a discretion that the judges can allow you to even file a suit after 3 years if they accept the condonation or they condone the delay and then accept the suit as well. However, the fact is that will not in any way touch the security that the bank has. So the bank can deal with its securities even beyond 3 years. Right? That's something that the bank always has a right upon. And that's why we say under the limitation law, which is based on the doctrine of latches, that's what we say. Yes, doctrine of latches is the doctrine of delay. Uh, you know, under this doctrine of latches, which is the rule of delay, it would exhaust your remedies, but it would never exhaust your right. That's a very popular statement that we always say. It will exhaust your remedies vis-a-vis the fact that, look, you can't file a suit and exercise your remedies. Right? If you wish to do that, you have to do within 3 years. Beyond it, you cannot. However, it does not exhaust your right, which means towards that kind of security, the bank continues to hold the security. They can sell the security at any given point of time. That right they could still continue to hold. But the fact remains that, please note, if the bank decides to sell, the law and the section very clearly says that a notice has to be served. Now, if the bank does not serve a notice, the sale will be invalid, it will be illegal, and again, the borrower can have a grievance regarding the same. So, what is provided in the statute as a mandatory notice must be actually complied with. And if the bank fails to comply with the same, then the borrower can definitely say his rights under the contract of pledge has been adversely affected by the bank. This is how the contract of pledge spans between both the parties in a contract. And please note, these are facts that no private contract can negate, intervene, waive, or diminish, because these are statutory rights that are granted to contracting parties. Right? That's how the law on contract actually deals with the rights of the parties as well. Finally, to look at what are the rights of the pawner, of course, the right of the pawner is the right to redeem. Very interestingly, what is redeem? Redeem means that the owner, the bailer, and the pawner, who actually were the original owners of the goods and they have pledged these goods to get a money advance, they can redeem the property anytime before the actual sale takes place. That means even after default, if they wish, they can actually pay the loan plus the interest and the extraordinary expenses, whichever is there, and still they can take their goods and make it their own. So the right to redeem continues to be a right for the lifetime of the owner till the actual sales takes place. And interestingly, even during this sale, there is a possibility that you yourself can take part in that kind of a sale and purchase the goods as well. That is some kind of a controversial point to be held in this kind of a fact situation, because you say there is a right to redeem, and hence before the ownership in the goods gets transferred to the third party, you can actually claim it to be your own. Right? So that's one of the rights of the pawner. It's called the right to redeem, and that is a right that can be exercised before the bankers sell it to some third party.